Welcome to my YouTube channel. I am Professor Satya Prakash. In my last presentation, I talked about the introductory lecture on jurisprudence, and in that lecture, I told that we can start studying jurisprudence and legal theory with the schools of jurisprudence. In my last lecture, I mentioned 7 schools. The first of those 7 schools of jurisprudence is the Analytical School of Jurisprudence, which was propounded by John Austin, who was on the chair of the London University in law school. He was born in 1790 and his lifespan extend to 1859. Initially he was a soldier in army, then he studied law and visited Germany also to know about the status of law and nature of law being taken in the continental states. He delivered 6 lectures in the University of London in 1828, which became the nature of law or the theory of analytical approach propounded by John Austin. The book titled Province of Jurisprudence Determined was published in 1832. He said that jurisprudence is the philosophy of positive law or the positive analysis of the legal norms and precepts. So from the angle of Austin, jurisprudence deals with positive law only. And he insisted upon the method of Austin was the analysis of the existing law, the present law or the existing law, and not about the future law. Or in other words, the law as it is and not as the law ought to be. So his method is known as analytical, and this school is also known as positivism because he took positive law only as the matter of study under jurisprudence. This is also known as analytical positivism, and C.K. Allen has termed this school as imperative theory of law on the basis of the nature of law propounded by John Austin. So, Austin defined law as the body of rules made by an intelligent being for the intelligent being having power over him. It means that the lawgiver and the person for whom the laws are made are different. One intelligent being gives a rule which is being followed by other intelligent being. Or in other words or simple words, we can say that a supreme authority gives the rules or laws for the regulation of the conduct of masses. He divided law into 2 categories, basically laws properly so called and laws improperly so called. For laws properly so called, he further divided them into 2 categories: the laws of God, means the law given by God for the conduct of the people or the individual, and the other is law given by, or in the sense that they are human laws or given by human beings for human beings. The one category is positive law, the laws strictly so called, which are given by political superior for political inferior in the society. These are called positive laws, and these laws are the only subject of study under jurisprudence. It means that there is some superior or supreme authority in a politico-legal society. He said that such society is known as political and independent. And the other human laws are laws made by man for man, not as the political superior, but as man only. And in this category, or he said them as positive morality. In this category, he put laws made by master for servant and laws of a club, because these laws are made by man for man, but they are different from positive or from the positive law because there is some authority. The law giver and the law abider are different. In positive morality, the laws are given by the human beings for themselves. It means there is no superior authority, but ultimately these laws are to be followed by all. The other category, or the laws improperly so called, are further divided into laws by analogy and laws by metaphor. Analogy and metaphor means that they are being called law, but actually they are not laws. So, in laws by analogy, he put the laws of fashion, and international law also was categorized under laws by analogy. And in laws by metaphor, he gave the example of laws of universality of nature, or like law of gravitational force. Then the main point is that the lawgiver and the subjects are different. He said that from the definition of law, that law is a body of rules made by an intelligent being for the guidance of an intelligent being having overpower him. This word, having overpower him, means that there is difference between lawgiver and the law abider. He defined law as command of sovereign. Means the law is given by sovereign and it is in the form of command. Command means an order supported or backed by sanction. There is no alternative to the command, or in other words we can say that command is an order which is to be followed by the person to whom the order is given, and in case of non-compliance there would be adverse consequences, and the very simple consequence may be the punishment to the person who is not obeying the command. He said that every law creates a duty backed by sanction. So the law, duty and sanction are related. the law, command and duty are also related. In this sense, every law is command imposing a duty enforceable or enforced by sanction. The force behind the order, the force of adverse consequences, the consequences which would not be in the favor or in the interest of the person who is not abiding by the command of sovereign. He said that in a sense, sovereign means the supreme authority. Or in other words, we can say a supreme authority, the like of which is now not found in that society and who is not under any external supervision or authority or control. In this manner, there are two elements. One is internal element, the other is external element. That there should not be any other authority or person within the state, and there should not be any external control on the sovereign. From the angle of technical definition of a state, there are four elements or essential conditions. First is there must be territory. Second, there must be population or people. Third is there must be government to regulate the relation of or conduct of the individual. And fourthly, the sovereign. Sovereign is the most important element of statehood. There cannot be a state without having any one or more of the elements of statehood. If one element is missing, that cannot be treated as a state. So he said, initially, he said that sovereignty vests in a single person. But when it became very difficult to recognize a single person as sovereign, he said that it may be in an authority or in a group of persons like Parliament in Britain, because the Austinian structure is based on the study of British system of governance. So it may be in the authority or in a group of people, but that should be a single authority. There should not be more than one authority which may be called as sovereign. He said that sovereign is essential. Secondly, continuous. The sovereign is essential, continuous, unlimited, indivisible, and illimitable. There cannot be a political state, politico-independent state without sovereign. It means sovereign is essential. Secondly, it must be continuous. There cannot be a state without sovereign for any time or any friction of time. A sovereign is succeeded by another sovereign. Thirdly, the sovereignty is indivisible. There must be a single sovereign. Though later on, when we have criticism of Austin, this indivisibility is not applicable on federal system. And therefore, because in federal system, the authority is divided into central authority and the authority of units or state. But if we take into consideration both the elements of sovereignty, then the external sovereignty or the lack of control from any external power is applicable on the central authority or the federal authority. Therefore, in federal system also, the concept of sovereignty may be available up to a good extent or reasonable extent. It cannot be said that Austinian concept of sovereignty cannot be applied on the federal system of governance. Secondly, in most of the countries who have federal system, there is constitution, and constitution provides about the authority, powers, duties, responsibilities and relation of central or federal authority and the authorities in the units or state. So constitution is considered to be legal sovereign or de jure sovereign. So sovereignty is indivisible. Thirdly, it is unlimited, means there is no limit or there cannot be any limit on the powers of the sovereign. And lastly, it is illimitable. It means it cannot be limited even by the sovereign. The general concept of power is vested in the sovereign, and even the sovereign, in normal cases, there may be some exceptional cases, but sovereign cannot limit its own sovereign authority. In that case, it would not be a proper sovereign if a sovereign authority or the government or the parliament is making some law or some executive order which is derogatory to the supreme authority of that state, or under the control of some external body, or under some impression of the external body, which may not be considered as fully independent decision, then also it would not be a sovereign authority. Therefore, he said that sovereignty is illimitable. Though other thinkers on jurisprudence, Jeremy Bentham, said that sovereignty is essential, continuous, unlimited, but it cannot be illimitable. There should be some limit somewhere. So, because the background of Austin was so that he worked in army, so he gave absolute authority to the sovereign. So the main crux of Austinian theory is that law is given by some superior authority for the inferiors. In modern sense or sociological jurisprudence or ethical jurisprudence, we say that all individuals are the members of society, and some of them, like in democracy, it is the government of the people, for the people, by the people. So the people, ordinary people, are factors in the formation of government. So then he told about certain laws which may not be considered as direct command. One is, as I said, that divine law or law made by God for man. But why did he include laws made by God for man in the laws properly so called? Because the lawgiver and the law abider are different. They are not positive law, but they may be said as divine law. Secondly, the positive laws which provide some privilege. A law providing privilege is not providing some duty, but they are providing some privilege. And thirdly, the laws of imperfect obligation. The laws which cannot be enforced by a process of a state, that is judicial process, and some laws may be declaratory law, which declare already existing law or some explanation about the existing law. So they cannot be or should not be considered as command, because command has already issued. So the method I said, it is known as analytical positivism. Positivism means the study of existing law, and positive law means the law given by some superior or sovereign authority. The Austinian theory is being criticized by some other writers, thinkers in general, like that he ignored the customs. But the answer to this criticism is that why should he consider custom as law? Because when he propounded the command theory or the theory based on sovereignty, so and there is no participation of masses or general public, the law is given by some superior authority, so there cannot be a custom being considered as law from the angle of the structure propounded by Austin. But if the custom is incorporated in the main law or by the legislature, then no doubt it becomes the law of the land. The law conferring privilege, he himself said that there may be some command which may be exception to the command or establishing some duty. Then people also criticize Austin on the judge-made laws or precedents. He said that there cannot be a conflict between the sovereign. Sovereign can be single authority. So if the sovereign, like in Britain, legislature is sovereign, so if they recognize any precedent by the higher judiciary or highest judiciary, then naturally it may become the part of the law. Convention have the same status of what the customs have. So unless and until they are recognized by the sovereign or the sovereign authority, so they cannot be considered as law. One most important point is that he did not consider international law as the law. He put international law in the laws though made by humans or human beings for human beings, but they are being put in the category of positive morality only, along with the laws of fashion. Because the crux of Austinian theory is that there must be a superior or supreme authority for making and for the enforcement of laws. In international law, the first point is that international law is not made by some external or superior authority. The international laws are made by the states themselves under the multilateral treaties or are based as a source of international law. Conventions or customs are treated as the older or ancient source of international law, then conventions or the law declared by the International Court of Justice, but they are not binding as precedent even on the states. So there is no over and above or superior lawgiver, and secondly, there is no authority to enforce or to impose sanction. So though there is international organization, UNO, and they have enforcement authority also, but actually it is not working. So in this sense, we cannot say that the concept of Austin not including international law under the head of positive law is wrong. So from his angle, it can be considered as positive morality only and cannot be considered as positive law. He put laws of fashion also under positive morality. Fashion means an abrupt change being followed by the masses or majority of people. It means that there is a change, but change is within the society. There is no over and above giver of the fashion, but if some fashion that may not fulfill the basic or fundamental rules of fashion even, or rules of some dressing or attire, but if something happens suddenly and the majority of people or masses follow that, that becomes a rule or law, but not positive law, positive morality only, that people generally follow that law. Like international law, generally the civilized state, as Oppenheim defined international law or this law of nation, that civilized nations follow international law in their relation with one another. So regarding sovereign, when we say that sovereign is the highest authority or supreme authority, the question arises in many states that who is the sovereign. Like I said that in Britain there is no written constitution and legislature has the absolute power of lawmaking, and society is being governed by law because there is concept of rule of law. So in Britain it is clear that legislature or king in parliament is supreme. King is also part of the legislature or parliament. The problem is in countries like India or US, I discussed about the division of sovereignty in federal state, but the external control is being avoided by the central authority. In countries like India, where we have very strong constitution and the society is governed by constitution, it is the basic document or the fundamental document or fundamental law of the country. So the law expert treat constitution as the de jure sovereign or legal sovereign, and president in parliament is considered to be the de facto or working sovereign, and or day-to-day sovereign or actual sovereign, de facto sovereign. And thirdly, the people of India, or you may say the citizen of India, are considered as ultimate sovereign, because ultimately they have to select the government of the day, because we have parliamentary system. The executive is based on the number of legislators or the members of central parliament, and also in the state parliament the chief minister is responsible to the lower house of the legislature, and therefore the executive is being made on the basis of the strength of the party in the lower house especially. So people are the ultimate sovereign, and they can change the government after a period. In India it is 5 years. So from the political science angle, the constitution is considered as the philosophical or theoretical sovereign. The parliament or the president in parliament is treated as the de jure or legal sovereign, and the people of India are considered as the political sovereign or the ultimate sovereign. So there is not much difference, but because law people say that every system in countries like India, where we have a very lengthy, big, vast and very effective constitution, the main pillar of the society is constitution. Every organ of state, whether it is legislature, executive or judiciary, relation of state with the people, relation of various organs of the state intercede, everything is governed by Constitution of India. Therefore, from the law point of view, Constitution is the legal sovereign or de jure sovereign, because every confusion, every dispute is to be decided by the interpretation of the Constitution. So this may be sometime discussed, that who is sovereign in India or who is sovereign in federal countries. So this may be an explanation for that. So with these words, I end today's lecture on Analytical School of Jurisprudence, or you may call it positivism or analytical positive or imperative theory given by John Austin. So in my forthcoming lectures, I would be discussing the other schools of jurisprudence. The second is pure theory of law given by Hans Kelsen, and after that I will discuss historical school, sociological school, economic approach, modern realism, and in the end natural law theories. So thank you very much and all the best for everything. Thank you.